In Ward v RAI, the Court of Appeal restored Deputy Cost Judge Friston's decision not to strike out a non-compliant point of dispute and to permit reliance on an annotated document schedule served 2 working days before the detailed assessment hearing. Point 23 of the paying parties' points of dispute challenged 134.1 hours of document time at £38,819.50 plus value-added tax, but raised only general criticisms, cross-referencing a schedule that had not been served. The cost judge declined to strike out point 23 under Rule 3.4 subparagraph 2, permitted reliance on the late schedule under paragraph 13.10 of Practice Direction 47, and adjourned to a 3rd day, subject to cost sanctions. Mrs. Justice Hill set that decision aside, but the Court of Appeal held that it fell within the generous ambit of the cost judge's discretion. Both parties were at fault, and the schedule was no ambush. The court nonetheless cautioned that paying parties should be under no illusion that paragraph 8.2 of Practice Direction 47 requires an approach compliant with Ainsworth v Stewart's Law LLP. Those who do not comply on a timely basis risk non-compliant points of dispute being struck out, or, as a minimum, cost sanctions. And late variations under paragraph 13.10 risk being disallowed or permitted only on conditions, including as to costs. Quote, "Paying parties should be under no illusion that paragraph 8.2 of PD 47 requires an Ainsworth-compliant approach. They should not assume that a lenient approach will be taken if they take a similar approach to the defendant in this case. Those who do not comply on a timely basis risk non-compliant elements of their points of dispute being struck out or, as a minimum, cost sanctions. Similarly, late variations by either party under paragraph 13.10 of PD 47 risk being disallowed or permitted only on conditions, including as to costs."
For a detailed summary of this decision, visit tmclegal.co.uk.